All right, we're going to go over to the court where the four police officers stand accused of having fatally shot Mthokozisi Ntumba.
He's currently employed as a police constable attached to the Public Order Policing Unit of the South African Police Service based in Diepkloof, Soweto, with a monthly income of 12,000 rands per month. Employed as an officer for 2 years. He has movable assets valued in the excess of 100,000 rands. The first applicant's legal representative, Mr. Kekana, submitted the following: that the applicant denies the allegations against him in the strongest terms. If kept in custody, the detention will result in substantial loss of applicant's respect in the community, personal hardship to the applicant and his family. The applicant has no pending cases, no previous convictions. Applicant is not a flight risk. He will not interfere with the state witnesses, will not commit further offenses while released on bail. Applicant has assets. Applicant has to be presumed innocent until proven otherwise at trial. That the applicant has discharged the onus. That the interest of justice permit that he be released on bail. And furthermore, that the applicant can afford to pay 8,000 rands bail. The second applicant, by way of affidavit, indicated that he will plead not guilty to the charges preferred against him. He is confident that if his case proceeds to trial, he'll be acquitted. He concedes that the offences he's charged with fall within the ambit of Schedule 5 of Act 51 of 1977, that is the Criminal Procedure Act. He is a South African citizen. He is not in possession of a valid passport or any other travel document. He is married with an unemployed wife, has 4 children. These children depend on him for a living, and he is entirely further responsible for their well-being and upbringing. He is employed as a police officer based at Diepkloof Police Station, has been employed as a police officer since 2007 to date. He earns a salary of 19,000 rands per month. At the time of arrest, he handed himself to the police officers after being advised that the police were looking for him in connection with the charge of murder. He did not resist arrest, nor did he try to run away. He cooperated with the police during the arrest. His address has been verified by the police. The police officers know where he works. He's a sergeant at Diepkloof Police Station. He is from Taung in the Northwest Province. He knows no other place he can call home other than Taung village. And his house is at 14925 John Mabaso Street, extension 11, Kagiso, Gauteng Province. He is emotionally attached to these places. He has no relatives or friends outside the borders of South Africa. The applicant further stated that he has never been previously convicted of any offense. He is not on bail on any other charges. There are no charges pending against him other than the offenses he's applying for bail in this application. Applicants submit that the interest of justice permit his release on bail on the following basis: he will not commit Schedule 1 offenses whilst released on bail. He will not endanger the safety of the public or any particular person. He's not a violent person. He is finding himself on the wrong side of the law for the first time at an advanced age of 43 years. There's no likelihood that if he's released on bail, he will attempt to evade trial, in that he has a family, friends, and close relatives within the court's area of jurisdiction. And as such, he is emotionally attached to this area. He cannot evade trial because he's a law enforcement officer and runs the risk of losing his job if he evades trial. He has a valid, strong defense to the state case and is confident that he'll succeed in his defense. He's indicated that he'll adhere to bail conditions and is prepared to pay a sum of 3,000 rands for bail. He will not interfere with state witnesses. He has never in the past failed to comply with bail conditions, and there's no likelihood that if released on bail, he will disturb public order and will undermine public peace and security. He is entitled to be released on bail. Applicant 2's legal representative, Mr. Mudau, submitted as follows: that the second applicant will not commit Schedule 1 offences whilst released on bail. The applicant will not evade trial in that his family is in South Africa and is within the court's area of jurisdiction. The applicant's address was verified by the police. He has a fixed address. The state will be in a position to locate him or find the applicant if he does not attend trial. That applicant number 2 has no passport and is not intending to apply for one. State witnesses are known to him, therefore, he will not interfere or intimidate state witnesses. And that the applicant has complied with the requirements of Section 60 of the Act, that is 51 of 1977, and that the interest of justice permits that the applicant be released on bail, and that the court should therefore release the applicant on bail. Through an affidavit, applicant 3 stated the following: that he is 37 years old, a South African citizen, born in Limpopo, currently residing at number 12131 Mahogany Street, Kagiso in Krugersdorp. He resides alone at the above address. He is currently employed as a sergeant in the South African Police Service since 2007. He has 3 dependents, a mother of 63 years of age, 2 minor children, aged 11 and 4 years old respectively, and they are financially dependent on him. Applicant has movable assets, including a motor vehicle, a Toyota Yaris. Applicant is not in possession of a passport. He is concerned about his personal safety in prison, as conditions in prison are harsh, especially with the outbreak of the COVID-19 pandemic. There's no guarantee of his safety. His siblings are unemployed and cannot take care and support his mother. The mother of his 2 children is unemployed. He's the sole breadwinner. His children are left without any finances for their basic needs, food, and shelter. If released on bail, he will not endanger public safety and security or commit offences whilst out on bail. He will not threaten any person or witnesses whilst on bail. He has no pending cases or warrants of arrest outstanding against him. He has 2 previous convictions of driving under the influence of intoxicating liquor, which happened 10 years ago. The applicant has no intention of evading trial all his belongings are within the jurisdiction of this court. Applicant will not intimidate witnesses, that is state witnesses, since they are unknown to him. If granted bail, he will abide by bail conditions. He did not supply the South African Police Service with false information before or after arrest. He gave full cooperation to the police. Applicant intends pleading not guilty to the charges against him. And the applicant humbly requests that the Honourable Court grant him bail, as it is in the interest of justice to do so. Applicant 3's legal representative, Mr. Morgan, submitted the following: that it is in the interest of justice that the applicant be released on bail. Applicant has the right to freedom. Applicant has to be presumed innocent until otherwise proven, and requests that the court should grant bail to the applicant. Affidavits by fourth applicant and his wife stated the following: that the applicant is a police officer residing at number 991 Botsi Street, Dobsonville, Soweto, is 51 years old, a South African citizen, is married, has a son of 11 years old. His wife is unemployed, was retrenched in 2020. He pays 1,000 rands towards his son's school fees. Applicant is employed in the South African Police Service with the rank of a warrant officer and has 27 years service in the South African Police Service. He is currently stationed at Public Order Policing in Diepkloof, Johannesburg. His net income is approximately 16,500 rands per month. Applicant is not in possession of a passport or any other travel document. He has never visited a foreign country, has no relatives outside the Republic of South Africa. Applicant has immovable assets, a house which is immovable, situated at 991 Botsi Street, Dobsonville, Soweto, valued at approximately 1.2 million rands. They had a vehicle, but had to sell such after his wife was retrenched from work. Applicant has no previous convictions, no pending cases, no pending warrants against him. Applicant denies having committed the crimes of murder, attempted murder, or defeating the ends of justice. He categorically denies that he shot or killed the deceased. He did not deliberately fire rubber bullets at any member of the public with the intention to kill anyone. He respectfully submits that the provisions of Section 60 sub 4 to 60 sub 8 of the Criminal Procedure Act 51 of 1977, that is on the balance of probabilities, are in his favor, and that if he is released on bail, he will not endanger the public or any particular person's safety, nor commit a Schedule 1 offense. If released on bail, he will not evade trial. He cannot afford to forfeit his bail money if released on bail. There's no incentive for him to evade his trial. He is confident that he'll be found not guilty in this matter. He gave full cooperation to the police, that is IPID. He went to their offices as requested and was placed under arrest. Applicant will not influence or intimidate state witnesses if released on bail. He has not disclosed false information to the investigating officer or the court at any stage. His release on bail will not undermine public peace or security and will not disturb public peace. His release will not lead to public disorder. His safety will also not be jeopardized by his release. applicant emphasized that COVID-19 pandemic is a serious risk for detainees in prison and accordingly requests that the court should release him on bail. The applicant's wife confirmed that herself, together with the applicant, have a minor son, aged 11 years old. They are residing at 911 Booty Street, Dobsonville, Soweto. The house was inherited by the husband from his deceased parents. She was employed at Pick n Pay Lenasia, but was retrenched on the 30th of April 2020. She is currently unemployed. The applicant is the sole breadwinner in their family. She requests the court to release the applicant on bail. He's not a flight risk and will definitely attend his trial. He's a person that respects the laws of the country. Fourth applicant's legal representative, Advocate Pistorius, submitted the following: that the applicant has family ties within the Republic of South Africa. He's not a flight risk. He's employed as a police officer. He'll abide by bail conditions if released on bail. He's married. He's a family man, a responsible citizen. There is an affidavit from the wife confirming his personal particulars, also requesting the release of the applicant on bail. Applicant should be presumed innocent. There will be no public outcry should the applicant be released on bail. That the state failed to meet the requirements on public outcry as spelled out in S versus Nell 2018 volume 1 South African Criminal Law Reports at page 576. That the applicant can afford 5,000 rands bail. That the interests of justice permit that the applicant should be released on bail, and respectfully request the court to grant him bail. The respondent, by way of an affidavit or affidavits from the investigating officer Judy Tinyiko Twala, stated the following: that she's the investigating officer of Hillbrow, CAS 225 of 3 of 2021, a matter where the applicants are arraigned on charges of murder, 3 counts of attempted murder, and defeating the ends of justice. The officer is employed by the Independent Police Investigative Directorate, holding the position of senior investigator. That on Wednesday, 10th March 2021, at around 11, whilst on duty, that is standby, she received a call to attend a crime scene of death as a result of police actions. The crime scene was at De Beer Street in Braamfontein. On arrival, she was informed that the deceased was shot by the police officers who were applicants in this matter, who were driving a police nyala. The officer found the deceased, later known as Mr. Mthokozisi Ntumba, lying on the pavement facing upward. The deceased had a bullet wound on the left side chest, a bullet wound on the left side under the armpit, and a wound on the right side next to the eye. 6 cartridges cases were found at the crime scene, which were taken by the Johannesburg Provincial CSI for further investigations. Investigations continued. Witnesses' statements were obtained. CCTV footages from the JMPD city cameras and JIET were obtained. On the 15th of March 2021, all applicants were arrested for 1 count of murder, 3 counts of attempted murder, and a count of defeating the ends of justice, due to the fact that applicant 1, 2, and 3 fired shots towards college students who were waiting for school bus in front of the college premises. Investigations revealed that the students were not violent. Applicants shot at the students without provocation nor posing danger to anyone. The 3 applicants were shooting at the students without any provocations. They should have foreseen the possibility of death or serious injuries occurring when shooting at close range. Applicants ignored and, of course, moved away from the crime scene even when an eyewitness showed them an injured person lying on the ground. Applicants failed to report the shooting incident to the commanders and also failed to cordon the crime scene. Personal circumstances of all the applicants were also investigated, stated in the investigating officer's affidavits. The officer is opposed to the granting of bail to the applicants because the state case is strong against all the applicants. The applicants are familiar with the identity of the witnesses in this matter and have got knowledge of the evidence against them. The family of the deceased, university students, and the citizens of the country are very disturbed about this incident. The university students and the citizens of the country are very angry with the manner in which the incident occurred. Once the news is out there spread that the applicants are released on bail, the community may hold protests and public peace will be undermined. Applicants will jeopardize the proper functioning of the criminal system, bail system if released on bail. There will be public outcry, lack of trust in our criminal justice system, considering the seriousness and the nature of the case. The officer is opposed to the granting of bail to all 4 applicants. For the respondents, Mr. Zuma submitted the following: that the state case is very strong against all applicants, that the applicants shot at innocent students at close range, that the applicants turned a blind eye on a person that was pointing out to them that there's an injured person, that the applicants failed to report the happenings to their superiors timeously. The applicants failed to cordon the crime scene. It is the duty of the officers to comply with the above. The officers were dishonest. The court should take that into account and deny bail to all 4 applicants. Officers shot as well at victims who are not students. Furthermore, the state is opposed to bail in that the student community, the community at large, is very angry on what happened, angry about the police behavior. If the applicants are released on bail, there will be community outcry. The respondents humbly request that bail be denied against all 4 applicants. In response to the submissions, the applicant's legal representative submitted that community outcries allegations by the respondent with no evidence tendered should not be upheld by the court. The Constitution of the Republic of South Africa, that is Act 108 of 1996, Section 35 thereof, on arrest, detained and accused persons, Section 35(1) states that everyone who is arrested for allegedly committing an offence has the right, at the first court appearance after being arrested, to be charged or to be informed of the reason or reasons for detention, to be continued, or to be released. F, to be released from detention if the interests of justice permit, subject to reasonable conditions. Section 60 sub 1A of Act 51 of 1977, that is the Criminal Procedure Act on bail, that is bail application of accused in court, states the following: an accused who is in custody in respect of an offence shall, the court's emphasis, shall, subject to the provisions of section 50 sub 6 and 7, be entitled to be released on bail unless the court finds that it is in the interest of justice that he or she be detained in custody. In State versus Atchison 1991 2 SA 805, a Namibian High Court decision, the following was stated: the common law and the Constitution demand an equilibrium between the importance of freedom and the broad interest of justice. The primary objective of the criminal process regarding the phase before trial is to bring the accused before a court and there to confront him or her with allegations of prosecution. For that the reason, the court gives its support when necessary to steps aimed at preventing flight, obstruction of the police investigations, interference with state witnesses, concealment or destruction of real evidence. The courts have done this by means of bail conditions and criteria which have been threshed out judicially over the years. In State versus Lamini, State versus Ladla and others, State versus Ubed, State versus Kitticut, 1999-2, South African Criminal Law Reports, 51 CC, it was stated that the question during bail proceedings is not about the guilt or not of an accused person, but it's about whether the interests of justice permit the release of the accused. In reverting back to the application before court, the purpose of bail is to secure the attendance of the accused to trial. During bail proceedings, the court does not decide on the question of guilt or not of the accused or the applicants before court. The onus is on the applicants to show on the preponderance or balance of probabilities that the interests of justice permit that they should be released on bail. The respondent is opposed to bail due to the possibility of a community outcry, student protests, and general anger and distrust of the justice system if the applicants are to be released on bail. However, the above being statements made from the bar by the respondent without any backup in a form of evidence, either by way of affidavits or oral evidence, does not carry weight. And statements from the bar do not amount to evidence. No community members from the general public or student community have given evidence for the respondent in support of his submissions. The trial court is the one that will decide on the guilt or not of the applicants and will deal with the merits of the case. During bail proceedings, the court should be very cautious of extensively dealing with the merits of the case. We ought to remind ourselves that the court is involved with offences that fall within the ambit of Schedule 5 as per the schedules in the Criminal Procedure Act 51 of 1977. The court has to be satisfied that the requirements of Schedule 5 as per schedules in the Criminal Procedure Act have been met. The applicants before the court are South African citizens, applicants have movable assets. The other also has an immovable asset, a house inherited from the parents that are deceased. The applicants before court have got no passports, nor any other traveling or travel documents. They've got no relatives outside the Republic of South Africa. They've got no business interests nor assets outside the Republic of South Africa. All four are employed as officers with the South African Police Service. The above indicates that the applicants are not flight risks. Applicants' families are within the borders of the Republic of South Africa, some within the area of jurisdiction of this court. This shows that the applicants have ties with the area where they might be tried. There's no concrete evidence before this court that if released on bail, the applicants will threaten or intimidate witnesses. No witnesses from the respondent were called on outcries by both students and the general community. There's further no concrete evidence before the court that if released on bail, the applicants will undermine the workings of the criminal justice system, including the bail system. There's no evidence that if released on bail, the four, that is applicants, will commit Schedule 1 offenses. All four applicants have indicated that they are employed, are in position to pay bail, and will abide by bail conditions. The court is satisfied that all four applicants before the court have adjusted the onus on the balance or preponderance of probabilities that the interest of justice permit that should be released on bail. In the circumstances, the following order is made. Applicants 1 to 4's application to be released on bail is granted. Bail is fixed at the amount of 8,000 rands per applicant or accused on the following conditions. 1, accused or applicant 1 to 4 should not threaten or intimidate any state witnesses, that is directly or indirectly. 2, accused or applicant 1 to 4 should not make any contact with state witnesses directly or indirectly. 3, accused or applicant 1 to 4 should not apply for passports or any travel documents as from today, that is the 26th of March 2021, until the finalization of this matter. At this stage, the court will invite from the respondent any further bail conditions to be added before remanding this matter. Are there any? If there's none, then what would be the remand date?
The further condition is to ensure that the court mentions the issue of visiting number 27 to be selected place the primacy. The applicants should be also for the
Someone please. Number?
It's number 27, the BS Street, Braamfontein.
I take it is from today up until the finalization of this matter.
Second issue.
The fourth condition will be that the applicants or accused 1 to 4 before this court should not visit number 27 DBS Street, Braamfontein, as of today, that is 26 March 2021, up until this matter is finalized. Any other? None. Can we have anything from the... This one? Yes.
Position of the crime scene.
Yes.
Can we possibly consider that, except if the accused is in the presence of their legal representatives for purposes of preparation for trial? Because obviously applicants certainly will want to visit the crime scene, alleged crime scene, in order to give instructions to them.
Charged with the murder of Mthokozisi Ntumba have been given bail of 8,000 rand each, and that comes with a number of conditions: that they mustn't threaten state witnesses, they mustn't contact any witnesses, they mustn't go to the area where the incident took place, where Mthokozisi Ntumba was shot in Braamfontein, and they mustn't apply for any passports from this day forward until the matter has been finalized. So they've been granted bail of 8,000 rand. My colleague Nzinga Kunta will have more news for you at the top of the